Hey everyone, it's Rob Ryder. We are here today for improper venue motion, in which a case was dismissed on June 22nd, 2017. Plus, to talk about the official court reporter, and you, and how this person, from having this case dismissed, we're finding out, hey, there's somebody else we need to go talk to. It'll make more sense as we go on. But on the 22nd, Billy had a court hearing in which the prosecutor said, we're here today for an improper venue motion. Well, the only one of those there would have been was the one that Billy put in, saying that it was an improper venue. And they held a motion hearing. Outstanding. In which the case was dismissed. Even better. But it could have been better. Because really, they let Billy decide what it was he wanted for a judgment. And he said dismissed with extreme prejudice. Kind of forgetting that he had put in an order saying what he wanted. So, not that that matters. We'll get it next time. But these are the things, right? They're always trying to be clever. They're clever people. There's no doubt about it. So we need to stick with the truth. And this is Saturday, June 24, 2017. I'm Rob Ryder. My email address is courtofrecord, COURTOFRECORD at AOL.com. Phone number 616-712-6179. Two easiest ways to get a hold of me. If you can, please donate. That's how I am able to do this. And I'm hoping I don't have to do it much longer without saying, hey, here's a real remedy. In fact, here's one right here. Case was dismissed. So it can happen, right? And I don't say that we haven't figured out exactly, but the idea is to figure out what works and do it again. And if it works, it'll work for pretty much everything, because we're pointing out the fact that they brought the case in an improper venue. You can also use snail mail, check, money order, cash. Robert Retluski, 10955 14 Mile Road, Northeast, Rockford, Michigan, 49341. I used to, on a couple of videos, I said to use Western Union or Walmart, but I just assume now that after looking at it that you don't. They make it kind of hard to get your money if you don't have a valid, in their mind, identification with a picture ID, which right now I don't have. So, well, we'll leave it at that. And just a couple interesting things. I had to put this on the front screen because it's just too good. This is a Michigan compiled law that I found in the manual that has to do with these court recorders. Although it's a Michigan compiled law, it's always been there. I just had never read it before. And it's rather long, but it gets to a point where it says, a defendant in any criminal case or proceeding shall only at his own request be deemed a competent witness, and his neglect to testify shall not create any presumption against him, nor shall the court permit any reference or comment to be made to or upon such neglect. So in other words, unless you tell the court that you want to be a witness for yourself, you're not considered a witness, or at least a competent witness. This means a living man type stuff. And so, hey, you never really appeared, right? So a defendant in any criminal case or proceeding shall only at his own request, I guess that means you have to tell somebody, be deemed a competent witness. You need to tell somebody you want to be deemed a competent witness. Now, who the heck the somebody is always the question, but at least we know what to tell them when we find them. And so until that, you just tell everybody you meet, I want to be deemed a competent witness in my hearing. Or it's a violation of my civil liberties protected by the Constitution. Or better yet, deprivation of rights under color of law in violation of 18 U.S.C. 242. You should write that down. Deprivation of rights under color of law in violation of 18 U.S.C. 242. So in this hearing that was on Thursday, which was the 22nd, Billy's nephew, Dakota, was sitting in the stands, basically, and he had pointed out some things, as had Billy, but Dakota gave me a couple different ones. Like he noticed that the elected sheriff was the court security in the courtroom. Right now, this isn't a trial. There's no jury. This is a hearing with the prosecutor and Billy and the judge and the judge's recorder, whatever. But did I put this in here? I better. No. Okay. So I should say it right now. So not only is the elected sheriff standing there as the court security, like the frickin' bailiff would be, right? He's the bailiff in the court, elected sheriff. I don't know how often that happens. And they had not scheduled any. They had cleared the docket. That's what I'm looking for. Cleared the docket for the afternoon. And in the last hearing, which Dakota went to also, so there's two hearings basically, but in the last one, he said the sheriff was there also, and in that case, they had dismissed all the other cases in the docket for the afternoon. And I believe I talked about that in the last video I did, which had to do with Samuel G-Rod was tried at a venue beyond the sea. So the one just before this, which obviously they both tie together because of the venue aspect. Because that's what got this hearing. And in this hearing, Dakota's now pointed out to me in a phone call, the elected sheriff was the county, or was the court security. The prosecutor stated the hearing was for a motion for improper venue. So when they got the thing started, it was the prosecutor that said they were there for a motion for improper venue. Well, during this, this trial or show court that's going on in the courtroom, the judge stated to the prosecutor that there was no complaint in the court file. So you got to think about this, right? We're here for a motion for improper venue, and we'll have to see what the improper venue motion looks like. But basically, we're saying that the prosecutor's in contempt of court because he brought this criminal matter into an improper venue, right? Which is a violation of the Constitution. Blah 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 blah. We'll just go ahead and read it in a minute. But it was the judge who stated in the record that there was no complaint in the court file. The traffic cop who had made the stop that caused all this was there to be a witness, but he was in street clothes. He took the stand in street clothes. Now, I've not been to that many court cases, to be quite honest, so I don't know how often if the officer is there in street clothes or not normally, but I'm saying in this case he was there in street clothes. I would have figured they'd be there in uniform. Right? This is a traffic cop. He's not a detective. Right? He's not wearing his uniform. He's wearing street clothes. So during this hearing, the prosecutor entered exhibits into the case. And these exhibits were evidence of errors and omissions that had been made in the case that really showed his contempt of court. Well, anyways, no matter what, he still took them and he handed them to the court reporter, who applied exhibit stickers, gave them back to the prosecutor. The prosecutor walked by, showed the defendant, Billy, what it was, took it over to the witness, read the name of what it is, and gave it to the witness and asked him if he had ever seen it before. And these were things from the village where this traffic stop was supposed to happen, such as the ordinance that was supposed to be there and his authorization for his MCOLS certificate, which he didn't have, but just a paper in the string of what would have to be done, asked the questions about it, and then gave it to the judge. And at the end of it all, the court reporter asked Billy if he wanted a seal on the alleged dismissal order. And we'll have to see why I say it's alleged, because the numbers aren't right, and there really isn't much on the piece of paper. But the court recorder did put a court seal on it. So the court reporter then went to the recorder station, which is where the recorder sits during court, and that is where she got the seal. And the seal says the circuit court, or excuse me, the district court for the, across the top and at the bottom, has the state of Michigan. Now it is in all caps, but it still says the state of Michigan, which would be significant because I'm going to show you another one where it doesn't say state of Michigan, the state of Michigan, it says state of Michigan. And so, to me, it's just evidence, well, there is two venues. They're showing it right there. We're having a frickin' motion hearing on the fact that it's a improper venue, and nobody's just denying that it is. Right? Nobody objected. And when it was all said and done, Billy got what he asked for. Case was dismissed. So some interesting things. And I'm going to try to do a call with Billy and his nephew Dakota, and do that as a separate video. But that's just to kind of set the table so we can go through the 1, 2, 3 of things here, which is what we're going to try to do now. So let's move on. Okay, so what the heck happened? Let's just go up here. So here's the court copy. You open up a few documents. Yep. Okay. Let's start with this, right? This is the original ticket that they stopped Billy on. And it's the state of Michigan uniform law citation. As it turns out, they take the number for the ticket, put a couple letters before it, and boom, they try to make that to be the court case number. Okay. But it was a failure to provide license, no proof of insurance, expired plate. Right? No driver's license, no proof of insurance, expired plate. Case dismissed with prejudice. Well, that's what it was. And it was filed in February. District Court 64A, which is in Ionia, Michigan, by some guy who was a cop for the Lake Odessa Police Department. Like I said right now, officer, I don't have anything against you personally at all. You're just on the wrong side. You're probably a really good man, trying to do the right thing. But you know what? The devil has that system all wrapped up, and it's those prosecutors that are the false accusers, and they're using you to do their dirty work. And I can't stand for it. You're going to have to find something else to do, and well, that's what we're here for. What else can we do besides, falsely accuse each other? Well, first thing we need to do is stop doing that. Okay, so that's what that looked like. And then this is all that really is. So this is the court's idea. 64A District Court. I guess that's People versus Roskin. File number. And the file number doesn't look right to me. But 2608 is close. There should be a 1 in here. 26018. Right, so it's not exactly right, but it's dismissed with prejudice. Raymond P. Voigt, District Judge, 6/22/2017, and here's that seal, and I hope that you can see that it says the state of Michigan across the bottom. The District Court, and I believe it's OF that's hiding here. It's not 4, it's OF. Okay, and we're going to compare that to a different one that he had gotten, which was a satisfaction certificate of satisfied judgment, which happened to come during this time we were doing all this stuff, kind of out of the blue. But there you can see it's the District Court of and the is at the top, and it just has the bottom, state of Michigan. Okay, well, this is the venue he started in, but he ended up in a different venue. He ended up in this venue, the state of Michigan. And it's this one that dismissed the case. So the same set of facts, and this is the thing about different venues, is the same set of facts. In one case, you'll be found guilty, and the other one you'll be found innocent, because the venue determines the municipal law to be used. The jurisdiction of the court, how they're going to try the case, goes with the venue. And so it's not County of Ionia, it's Ionia County. right? The thing is, they have to try the defendant in his county. And your county is basically a territory. And the territory, the word county is just a lowercase. It's a common noun description of some defined territorial land that happens to have a proper name. In my case, it's Kent. Here, this one, it would be Ionia. Okay, so nothing really well, I don't even know what to say there. Let's go and continue on. Just look at a few more pieces of paper. So here it is, LO26018. That's pretty much the proper number. This is supposed to be from the Ionia County prosecuting attorney. No ops, no proof of insurance, expired plates, right? That's the offenses. You see, there isn't any state statutes listed. There's no ordinance numbers. There's nothing that was on the ticket. They're trying to get you with words, not with numbers, because they don't have any authority to charge you with the state law. They're trying to take you to this other venue, get you to agree to this, get a judgment, and then take it as a foreign judgment to the proper venue to have it executed. I think that's the plan. This doesn't say the people of the state of Michigan, which it's supposed to say, and it doesn't have Billy's middle name, so they're really not charging Billy, the living man. It's, any number of people can be called Billy Roskin. It was back in 214. And so it's these people here. I mean, the prosecutor that's now sitting here in June saying to the judge, we're here for a motion having to do with improper venue. Oh, I don't believe he liked that. Okay. So I think that in Billy's case, they had actually changed, the judge had actually changed the venue before, because the judge has the power to change the venue. The court can always change a venue. And sometime after that, Billy got something from the prosecutor's office, and I couldn't find it today, that's why I'm not showing it right now. That one of the things that the prosecutor wanted to do was to change the venue. And then blah, 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 2 or 3 things. And Billy sent it to me. I said, well, that's strange. He wants to change the venue. No, we don't want to change anything, right? Because I think that we've done something. He wants to change it back. So just tell him you don't understand anything he's saying, and you're going to just go with the way it is. And you'll see him in court on it was like the beginning of June. And so we didn't agree to change the venue. But I believe the venue had already been changed because this started out by sending, in Billy's case, right? I had talked before about sending letters to chief judges. Well, we sent this to the Chief Justice of the Supreme Court back on March 10th, 2000, or March 7th, actually. And basically, Chief Justice Markham takes you this notice. I, Billy Joe Roskin, claim my civil liberties protected by the Constitution of the United States of Michigan are violated by individuals under Michigan Supreme Court's administrative control. I am the victim of a public wrong from which I demand relief and remedy and equity. I am denied due process of law and being secure in my persons, papers, and effects. Blah, 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 blah. Then what was going on? And the reason for that was because in Michigan, it says that the Supreme Court has, superintending control over the practice of law in the state. So let's go bitch to them instead of to the chief judge, as I had in other ones. I wanted to see what would happen if you went to the Chief Justice. Well, on the 10th, which is 3 days later, Billy, no middle name, Roskin's getting a response from the Michigan Supreme Court Office of the Clerk. This is a response to the papers we recently received from you addressed to Chief Justice Markham. Your papers did not reflect, and I have found no other evidence that you have a recent order or opinion of the Michigan Court of Appeals that could be the subject of application for leave to this court. Your papers appear to relate to district court matter. If you're dissatisfied, blah, 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 blah. So he's trying to make it sound like, well, we're trying to appeal something, a court case. And that isn't what we were doing. We were complaining about the practice of law in the state and using the court case as evidence of the deceit. Excuse me. So that's the official answer they give. And then how do they send it? Okay, so here it says Larry S. Roaster, Clerk, Supreme Court. Doesn't say Michigan Supreme Court on it. It just says Clerk, Supreme Court. Although his letterhead says Michigan Supreme Court, Office of the Clerk, right? Using a different title on the envelope than what's in the paper. I never did ask Billy, or maybe I did, I don't remember, if this was gold leaf seal up here and on bond paper, because I got an answer from the probate court a couple years ago that is on gold leaf, right? So it's under the seal, the great seal of the state, and it's on bond paper, and it's from the Kent County probate court, but it came in a letter, in an envelope that said probate court of the county of Kent, right? Not Kent County, county of Kent. Sort of like this, where it's got one address style or the office on the inside. And, well, Larry S. Roaster, Clerk, Supreme Court, no Michigan. Well, when he got that, it's like, well, what do we do now? I said, well, I think we need to send a second notice to the chief judge. But what Billy had realized, because soon after that he had a hearing, is that the judge, in the second time he had been in court, was already acting different than he had the first time he had been in court. And I kind of talked about that in the last video, I believe. And, it's a lot of history. It doesn't really mean anything in the future, so I'm not going to spend any time on it to just try to make all this make sense while we're looking at the paper. But, well, this is why you send things to people, right? So, so he said, well, what should I send back? So I just said, well, send something like this. Chief Justice Markham, this is your second notice to my claim my civil liberties have been violated by officers of the court administratively under your command, and from whom I demand you provide me relief and complete remedy and equity. Chief Justice, I do not authorize you to delegate this matter to a third-party intervener that hides their true identity behind a legal fiction pseudonym, false name, fictitious identity, then offer simulated advice to uppercase Billy Roskin. So basically, all that is about, well, we wrote the Chief Justice. Why is a deputy clerk writing us back? That's a third-party intervener. I want an answer from the Chief Justice. Billy Roskin is not my full legal name, and the use of any fiction in place of my full legal name in a legal matter is a simulated legal process by color of law in violation of the laws of the United States and Michigan. And specifically, you could say it is a 18 U.S.C. 242, deprivation of rights under color of law. Anyways, a.k.a. Inger Z. Meyer is a domestic terrorist, and you are her accomplice if you do not get off your fat ass and see to my remedy. Yeah, go ahead, tell them that. They'll leave you alone. Never bothered Billy. I hope he put that on there. I don't know if he did or not. I don't know that I read what he actually sent, but he asked me, and that's what I gave him. So all that was then, right? And then we're going on and on and on, and because that prosecutor had brought this thing up about venue, I said, I got to go study venue because I don't really know that I ever studied venue. Why would he want to study venue? And that's when it hit me like a ton of bricks. Oh, man, we're in two different venues. They take us to the wrong venue. And once you're in it, if you don't first complain that you're in the wrong venue, nothing else you do matters because you've agreed to the form of law to be used in that venue. And they use Talmudic law, right? As the defendant, you're going to lose. But they gave you an out. You just need to say it's the wrong venue. Well, that's what it should be. Now, having said that, I got a caveat for a second because we did another case last week for a guy that he actually had a felony case and he was going to trial. We were all the way down to the trial date. And in the trial date, it's the first time he ever brought up that this had been tried at an improper venue. And the judge was taken aback and didn't, so there was stuff going on. He knew what the dude had just said. And the guy said, yeah, but you come with all these hearings, da-da-da-da-da. But Jeff had the right answer. He said, well, yeah, that was under threat, coercion, and duress. I didn't have any choice. So they had a trial all day and went back the second day and had another trial. And at lunchtime, it was time for the verdict. And then the second day, because Jeff motioned for this, and the motion was in the paperwork, but I don't know that he actually motioned completely in the courtroom because I haven't really had a chance to talk to him again because he's in jail now. But the judge didn't do it to him. On the next day, the judge directed a verdict. Go look up direct verdict, which is really what the same thing that Jeff should have done. It's called a directed verdict to the jury, and um, they found Jeff guilty on all charges. That's what the jury said. And so then the judge asked a clerk who had never been there before, because now, and that's the other thing, now none of the people in the court are the same as the ones from the day before or the same as he's ever seen before. You got different clerks sitting in a chair, different clerk comes up and reads the verdict. The judge asks somebody to stand up. Is this the verdict of the jury? And he says yes. And but Jeff's standby attorney said, well, if the judge finds you guilty, they'll have you arrested immediately and revoke your bond. So that all happened. They had this verdict. That's the verdict. But the judge doesn't arrest Jeff immediately, doesn't arrest Jeff at all. Jeff goes. But they want him to get rid of the guns he has in his house because this was all about having a gun in the house and stuff. You know, it wasn't loaded, none of that shit, just happened to be in the car. And they made a big deal about it because, hey, it's a felony. They can, there's one we can put in the books. So that's Jeff's story. He went home. He was out all week. They wanted to come out on a certain day because he got a call from his bail bondsman who he didn't know. Why are these people here asking these questions? Because they wanted to not dismiss the bond, revoke the bond, which is probably what he wanted to have done because the whole thing's about the bond anyways. But they finally convinced him to come into court to talk about it or into the prosecutor's office. No, pre-trial service is part of the court. And he went in there and he didn't come back out. Like 4 days later from being let out by the judge in his hearing. And so he sits there today, and that's next week's project. And so I just want to put that in that, well, it didn't work for this dude. But it doesn't mean it won't work when we get it figured out, because at the time we didn't know about the court recording. And we're going to get to that part in just a second. Whew, you keeping up? Okay, because that's why I'm not talking to Billy and Dakota right now. This would be just too complicated. I'm really just trying to cover the high points of what looks really complicated, but if we get all the shit out of the way, it's really pretty fucking simple. Just petition the court and tell them it's an improper venue. And tell them the county of blank is not your venue. As the defendant, you don't have to prove you're in the proper venue. The prosecutor does. And when it came time for Billy's prosecutor to prove he was in the wrong venue, or that he was in the proper venue, because it had been challenged, the judge himself is the one that says, I don't have a copy of the complaint in the file. Okay. So what did we do? So then with Billy, we put in a motion for improper venue. And this is the way that Billy does it. Right? This isn't the way I'd have done it. This is how Billy did, but it's pretty much all my words, except I had and I'd put my name, Robert Allen Berlusky, right, petition. But I can see where you say, a man, the image of God on earth. Who might argue, right? Okay. Petition the court to take judicial notice that the plaintiff's attorney is an officer of the court who is in criminal contempt of court for prosecuting this matter in an improper venue in violation of constitutionally protected rights. I ask the court order these allegations be discharged and I be compensated for this malicious prosecution by grant of reasonable attorney fees and other equitable relief the court deems just. June 6, 2017. is when we put that in, and he finally had a hearing on it. Well, actually, I don't know when he put it in. I do. This is the day he had the first hearing where the sheriff was actually sitting there as the court security. And Billy had taken this and a bunch of other papers to court on that day to have entered into his case. And so they never really had a chance to look at it that day, and he didn't bring it up in court as a motion because you don't have to put motions on paper. You can do a motion in open court. But if you're going to file a motion, well, there may be a motion fee and all the other stuff that goes with it. But this is the motion that the prosecutor was speaking of that they were there for on that particular day. And the fact that it had been done in this manner, which people would say, well, that isn't how you do a court document, didn't seem to matter. We're there today to discuss a motion for improper venue, and this is the only one in that case that had been entered. Petition the court to take judicial notice. If you're a law enforcement officer or a prosecuting attorney, pay attention. Take judicial notice that the plaintiff's attorney, that would be the guy who claims to be the prosecutor, is an officer of the court who is in criminal contempt of court for prosecuting this matter in an improper venue because it didn't happen in the county of Ionia. In violation of constitutionally protected rights, I ask the court, order these allegations be discharged and I be compensated for the malicious prosecution by a grant of reasonable attorney fees and other equitable relief the court deems just. State a claim upon which relief can be granted and then ask for your relief. And you don't need to know exactly what your relief is. You just need to know you're due a remedy. And tell the court to do what's right. And I believe that they would. And so this is what the judge could have found, and he was ready to find on this because at the end of the hearing he said, Mr. Roskin, I believe I know what Mr. Roskin wants the court to do, but what do you want the court to do, Mr. Roskin? And that's where Billy says, dismiss with extreme prejudice. Nothing wrong with that, but it's kind of like forgetting that this was in there, right? Because the whole hearing, although I didn't look at it, you wouldn't know it by looking at it, the whole hearing, the whole time had to do with a hearing on a motion for improper venue. And this is the one that was in the record. Okay. So that's really the story for now with Billy, right? And the improper venue motion. I don't know what they did to the cop. He was in a business suit. I don't know what they're going to do to the attorney. I mean, as far as I know, I can see Billy let him off the hook. He could still be there on Monday. But his ass was just about headed back to the fleet, as Lord Coke would say. And so if not him, well, the next one. But all of that got me to look more at this person called the court recorder, because it was the court recorder. After all the smoke had cleared and people had left the courtroom and Billy was putting his stuff together, and he pointed out to the clerk, rightly so, why are there blanks here with nothing written in them? Right? You don't let them ever give you a piece of paper that don't have blanks in it, or that have blanks on it, right, without questioning it. What are those for? Acknowledgement. What does that mean? I mean, there should be something down here. We don't know what that level is yet, but he had asked her about that. She said, well, that doesn't really have to do with you. She said, but I can put a court seal on it for you. Boom. She put that court seal on the document. And all I can tell you is it says the state of Michigan on the bottom. And that is the name of the free and independent state according to the Michigan Constitution of 1835. 1835, the first one they wrote, it's in the preamble. Not state of Michigan, which has its own seal. It looks like this, state of Michigan. They have the same words, the district court of the state of Michigan. It's just where it is they put the word the. When it's at the top, that's the wrong venue. When it's at the bottom, in Michigan, well, it looks like that's the proper venue. So in researching about court reporters, it didn't take long at all. Just Michigan court reporters. Basically, Google that, and I found a manual for court reporters and recorders. It's like they don't want to be looking for this stuff. Somebody's really paying attention these days. It's probably been there for years, right? It's just now you're looking for it, boom, it comes up. So I'm going to kind of go through this, and this may take a little while, but these are important little things you might want to know. And you might want to go try to find a similar manual in your state for your court reporter recorder, because that's the person that had the seal. They're the keeper of the seal. That makes them the clerk of the court, right? Of the proper venue. There may be a clerk of the court for state of Michigan, but I want the clerk of the court for the state of Michigan. And that appears to be this person called a certified court reporter / recorder. So a court reporter or recorder is an integral part of the justice system. And they have these ones, they're called official. Okay, so I want an official. For me, it's like, okay, I want to find me an official court reporter. Sounds like somebody I need to talk to. The court reporter or recorder makes and maintains verbatim, permanent record of all proceedings, all ALL proceedings. You know what the first step of the proceeding is? File the damn complaint. Right? So it needs to go to the court reporter. Again, it's just the clerk of the court of the proper venue. We're going to the clerk of the court of an improper venue now, and we're volunteering to go to that improper jurisdiction. So even when you're the prosecuting, you're going to the wrong jurisdiction because you didn't go to the court reporter and give him your complaint. So conduct. The court, the reporter or recorder should be a respected citizen of good moral character and complete trustworthiness. Well, we're going to find out next week just how seriously they take this stuff. But it's their code of conduct. It isn't mine. When working in the capacity of an official court recorder, they're an officer of the court. Okay, officer of the court. That's good to know too. He or she should always recognize that an independent, honorable court is indispensable to justice in our system. Right? They're saying all the right stuff, and I know that people have talked to court reporters, recorders before, and you got your own opinion, but did you go to them in the proper hat? That's the person you're supposed to give your evidence to. As we're going to see, evidence isn't part of the court case. It is not in the court case. It's with the recorder. Communications between the reporter and the judge are to be highly confidential. The court reporter or recorder should maintain notes, records, stenograph tapes in accordance with law, the Michigan Trial Court File Management Standards. As an officer of the court, should always recognize that an independent honorable court is indispensable. The judicial system is for the benefit of the litigant and the public, not for the court or its staff. Let's find out if we can use that. In making records, reports, recorders should, blah, 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 accurate transcripts. I'm going to stop here, go find this other piece of paper. Because there's some important definitions that we need to know what a transcript is. A copy of any kind, that's a transcript. Right? So you give somebody a copy, well, that's a transcript. You make me a copy of something, it's a transcript. The Decalogue of Moses was but a transcript of the original. It's a memorial to the event. A writing made from or according to an original. And then what's a deposition? The act of giving testimony under oath. The attested written testimony of a witness. An affidavit, right? An affidavit is a deposition. So now think about this. Who do you give your affidavit to? You got to give it to the recorder. It's a deposition. And this is how you get them out of their sovereign immunity by doing a deposition, because it's the act of dethroning a king or degrading of a person from an office or station, a divesting of sovereignty or of an office and dignity, and deprive of clerical orders. A deposition differs from abdication, and abdication being voluntary, a deposition compulsory. So we need to have these people deposed. That's the reason. You dethrone them. They're out of their office and they can be tried in their private capacity, and they no longer will have any sovereign immunity. That's my theory. I'm going to go test it. Okay, so that was back to this. And they wanted to cooperate with qualified legal assistance organizations providing free legal services. There you go. We can find free ones. Got to get a hold of free legal services people and tell them you want to talk to a court recorder or reporter. I believe they're the same person. And they're going to abide by the Constitution, the laws of the United States, and the state of Michigan. Well, that would be 18 U.S.C. 242, deprivation of rights under color of law. Don't allow that to happen to me. I need you, recorder, to put my paperwork into the court, or they're not going to see it. Because I want my affidavit to be evidence. And evidence goes to the recorder, not to the clerk of the court, as we'll see. Definition and authority. An official court reporter is a reporter who is employed by or acting at the discretion of the Michigan trial court. Preparing official transcript. The authority, appointment, qualification, term, oath of office of individual court reporter are prescribed by statute and court rule. Each circuit court shall have as many court reporters as has judges. Probate court, one or more official court reporters. District court, there shall be not less than one district court certified court recorder or reporter for each judge of the district court. I believe this is the same person. There's not one or the other. I think that they do one or the other. But they're talking about the same person. It'll be easy enough to find out when we get to that level. Appointment. Chief judges collectively are the employees of all official reporters in this state. The authority and responsibility to supervise the performance of all court personnel, with authority to hire, discipline, discharge such personnel, with the exception of the judge's secretary and law clerk, if any, is vested in the chief judge. Now, the interesting thing is that in the circuit court, as we'll see, that one appointed by the judge is his secretary also. If they're your secretary, then they can't let him go. So it's like they've locked him into a position where the judge can't get rid of him now. And the one is watching the other. So it's like, oh, this is the English sheriff and the coroner, where the coroner takes the king's pleas, our affidavits, our complaints, logs them into their book, gives them to the sheriff, which is the judge, to have them executed, and then keeps track to make sure the judge does their duty, because it's logged in the book of the coroner. It was all stuff we did back in the day when we were studying Blackstone. It's wonderful. Circuit Court, according to MCL, some number 600-1104. I'll say it for the record. Every reporter or recorder in the circuit court shall be appointed by the governor after having been first recommended by judges of the court to which he or she is appointed, and he or she is an officer of that court. However, a governor has not appointed a court reporter since 1990. Instead, the court appoints court reporters in accordance with some other law. Well, or some court rule. Well, how does some court rule override the frickin' Michigan compiled law? How does a rule of a court override a law? This is very interesting, because this said recorder in the circuit court shall be appointed by the governor. Shall. So either well, that would mean shall has to be. If they're not, then there is no circuit court in the meaning of the circuit court, the way it's described in the laws of Michigan. Because here it was instead the court. It didn't say the circuit court. Now it's just the court appoints reporters and recorders in accordance accordance with MCR 8-110. So the circuit courts of the state of Michigan have been replaced by a thing called the court that's acting like the circuit court, but it isn't the circuit court that's written about in the state constitution or the laws of Michigan or so forth. It doesn't mean they won't enforce the laws. It means it's a different court. And the evidence of that is the gold fringe flag in the courtroom, because that's an Army flag. It's called the national color. It's the one the Army protects. That flag, the only courtrooms it can fly in, is a military tribunal. It's not a Navy flag. Navy doesn't have gold fringe in their flags. The Army has gold fringe in their flags. That is the national color. It's the Army's duty to protect that flag, and if it's sitting in that courtroom, then that courtroom is a military courtroom. And if the judge doesn't agree, you can call him a liar and tell him that. Take judicial notice. Judge, that gold fringe flag is an Army, that's the national color protected by the Army. And it only flies in, the only courtrooms it flies in are military tribunals. So either this is a military tribunal or that's a war trophy and you're an insurgent from King George III and his successors. But since 1990 something happened, because that's the last year that any recorders were appointed by the governor. Probate court. Well, the judge can do the probate court and the district court. Each judge of the district court shall appoint his or her own reporter or recorder. The Court of Appeals has held that the district court judge has the right and responsibility of selecting a court recorder at the beginning of the judge's tenure in office. The court expressly declined to consider the subsequent removal of a court recorder by the judge who appointed him or her. Once appointed, lifetime appointment, or at least a good cause, or what'd you say? During times of good behavior. Because the judge can't replace them or remove them once they appoint them. They have to appoint them at the beginning of their tenure in office. And so as long as that judge is the judge and that other person wants to be the court recorder and hasn't broken any laws, well, they can be. They can't stop them. Term of office. Every reporter shall hold office at the pleasure of the governor unless suspended for incompetency and misconduct by the court to which he or she is appointed. Again, the governor didn't appoint any circuit court recorders since 1990. So it isn't that it's not a valid court. I believe it is a valid court. It's just it's the court, not the state circuit court. It's a military court enforcing the state law. It's we've been under martial law since 1863. It was declared by President Lincoln, and there is no special peace treaty or special proclamation where it's ever been rescinded. The Civil War ended in an armistice, and so did the First World War, signed armistice. Well, those are just prolonged ceasefires, and so hostilities continue, and yes, there are still enemies, foreign and domestic. Oath of office. Before entering upon the duties, shall file the office, right? Constitutional oath, probate court. But the district court recorder, according to this, they don't do an oath of office. Okay, management. The chief or only judge of the court is charged with overall administrative responsibility for employees of the court. Well, you would believe that extends to his recorder, but he can't release them. The only way they can be released is by misconduct, and I have to think, well, that's when they would have to go to the Court of Claims to do that, which is under the Court of Appeals. Not that it matters today. It is primary responsibility of every trial judge to make certain the court reporter or recorder timely prepares and files transcripts and maintains exhibits. And so now the word exhibits comes into our vocabulary for today. Hey, They maintain the exhibits. What are exhibits? They're the things that are used as evidence. If the reporter is ordered by appellate court to show cause why she should not be held in contempt for failure to file a transcript. Okay, so the appeals court is the court that you would go to get in order to show cause why somebody shouldn't be held in contempt of court for not filing a transcript. You got to ask for, I think also you need to ask for the official transcript, not just the word transcript. We'll see, they like to use the word official here someplace. And these are all the things. Pending transcript report has the name, the file number, date, estimated length. Suppressed transcript. There appears to be no statute, court rule, or case law for suppressing transcripts. Exhibit maintenance. Exhibit maintenance is governed by a couple of laws and some standards in this file case management. Okay, now pay attention. Receipt and return and disposal of exhibits. Except as otherwise required by statute or court rule, materials that are intended to be used as evidence at or during a trial shall not be filed with the clerk of court, but shall be submitted to the judge for introduction into evidence as exhibits. Exhibits introduced into evidence at or during court proceedings shall be received and maintained as provided by the Michigan Court Rule, Michigan Supreme Court Case File Management Standards, as defined in MCR 1.109. Exhibits received and accepted into evidence under this rule are not court records. Exhibits received and accepted into evidence under this rule are not NOT court records. They're not in the court file. You don't put your proof in the court file. It needs to be entered as an exhibit to the judge. And because the way they do the district court, the one that the judge appoints for his recorder is also their secretary. And so why? You give them to the secretary to give to the judge. Pursuant to some other rule, if an appeal is taken to the circuit court, the offering party shall maintain exhibits in their possession unless otherwise ordered by the circuit court, trial court, or agency. Okay. At the conclusion of the trial, the court shall direct the parties to retrieve the exhibits that were submitted by them, except any weapons or drugs shall be returned to the confiscating agency for proper distribution. If the exhibits are not retrieved by parties as directed within 56 days, the court may properly dispose of the exhibits without notice to the parties. So you got 56 days to go back and get your evidence. All right, which is an exhibit. And just really quick, just so we can get this out of the way and I won't forget to have done it, rules of evidence. So what does all this mean to us as far as rules of evidence? Well, every state I have to believe, has their rules of evidence. And Section 9 where we get into requirement of authentication or of identification. Right? This is all about identification for us. We need to be identified in the proper venue. The requirement of authentication or identification as a condition precedent to admissibility is satisfied by evidence sufficient to support a finding that the matter in question is what the proponent claims, such as, right? So how do you authenticate that it is what it is? Well, testimony of a witness with knowledge, testimony that a matter is what it is claimed to be. Well, that's an affidavit, right? Testimony of a witness is an affidavit. And an affidavit was considered part of a deposition, and that's what court recorders do. So you can see, if you were to give your affidavit to the court reporter, that it could be entered as evidence into your court case. Now, whether you need to go to the notary public first, have them, give you an oath and take it that way, or give it to them and say, if you need me to take an oath, you go ahead and do it, because they're going to be notaries, notary publics. They can give you an oath. But the idea is, this is how you make it evidence, right? If you want to make it self-authenticating evidence, or evidence that is authenticated to be what it is, testimony of a witness with knowledge, that's your complaint filed under oath to the court recorder, acting as the secretary of the judge. It's not going to be part of the case. It's going to be the evidence of the case. And if you're doing it, pointing out a crime, then they're going to issue an arrest warrant in the name of the state of Michigan and make the prosecutor be the prosecutor for it. So you just turn it around on them, right? We put in proper evidence through our proper venue clerk, who happens to be called a court recorder / reporter, and don't argue with it. So we're going to be trying this next week, I'm hoping. Records maintained by the court recorder, who takes a testimony on a trial or the hearing of any case, shall prefix the record of the testimony of each witness with the full name of the witness. Hey, you've appeared. Your full name will be there, and the date and time the testimony was taken. At the conclusion of the trial, the recorder shall secure all records, property, and title them to on the outside, and shall safely keep them in the court. Transfer records to clerk of court. Well, if somebody leaves, then they get transferred to clerk of court. Not clerk of the court, clerk of court, which is the next person to go sit in that frickin' booth to do the recording where the seal is. That's the clerk of court. In that court, she's the clerk. That's the person the prosecutor walked up to with things he wanted entered as evidence and said he wanted entered as evidence. They put an evidence sticker on it, and he showed the defendant and went and gave it to the witness. Ask questions. Court to retain control. The court shall retain control over records relating to any proceeding held in that court, including those of court reporters or recorders who are not employed by the court. Right? So they don't apparently have to be official. You should be able to go find one, give them your paperwork, and say, I need you to file this in the court. This is my district court. And so here the district court would be the low court. Right? That's the court where traffic cases are heard. I'm believing. The only other one it would be is the appeals court, because it's split into 4 districts. And so I'm like in the 2nd district, or appeals court for the 2nd district, or something like that. Go look at the way they put the words. But they call it a district, so okay, that could be the lowercase district court. Well, we're going to go ask the recorders, hey, who's who? Who do we need to give this to so it's seen as evidence in a court case? And so I believe that it's the same court they're taking us to. We've been going to the wrong clerk. And if there's 2 venues and they each have their own clerk, we'll go find the other clerk and you'll be in the other venue. The operator is responsible for producing a record of all proceedings in the court. Yeah. Duties of the judge. The judge at the start of each proceeding. Okay, so if this isn't going on, right, if you're in a proceeding and this doesn't happen, you could say, hey, I must be in an improper venue. Verify the operator system's working. Advise participants it's being recorded. Advise them to speak loudly. State each case by name. Advise all participants to properly identify themselves when making their appearance at the beginning of each proceeding and to spell their names for the record. Well, I don't see how you get around that. That's how you appear. If you're not doing that, then you must be in the improper venue. And so it goes on and on. Just, there are a whole list of things that the judge has to do. Advise attorney to give their appearance at the start of each day. Advise attorneys to take necessary precautions. Mention coughing. Advise, conduct. Okay. Well, that'd clear that up, wouldn't it? Hey, this has to be an improper venue. I didn't State my name into the record. Sidebar bench conferences are part of the official record, so you're always on the record in court unless a judge says otherwise. All conversations of attorneys and parties that occur in the court are to be recorded. Courtroom check law. Hey, we just did this one. For some reason, it was in there again. Obviously, we don't have time to do all this, but these people have to be certified by the state, and they have a board, just like the attorney board, that if they don't do the right thing, you go to the board. That's what all this is about. But basically, they work for the chief judge, so really you go to the chief judge, you bitch to them, and they can take it to the frickin' board. You go to their boss, and they work for the chief judge. Reporting, recording the proceedings and depositions. Remember what a deposition is? That's an affidavit. Okay, notes. You're going to have to log notes. I guess I don't know why I put all these in here, but okay, so preparing the log for the day. They come in and they get busy, and case name, case number, court name, full name of the judge, full name of judge, and an abbreviation to use for the judge, date and time of hearing, full name and P number of the attorney, full name and P number of the attorney for the defendant, full name of witnesses, and abbreviations. Well, the defendant is actually a witness. If he tells himself, if you make yourself a witness, remember, unless you tell them you're a competent witness for your own defense, the court's going to deem that you're not, because it gave you the option to stay silent. But by staying silent, to them, it means you're not competent to be your own defense, to be your own witness. Abbreviating the name of the speaker saves the operative time, so you may see abbreviations. Exhibits. So, okay, it is important to clearly note on the log each time an exhibit is identified. So this log must be like a running log of the day in the court and what's happening in the court. So where does this person sit, right? Where does the district judge's recorder sit all day long? That's where you need to find. It is important to clearly note on the log each day an exhibit is identified, admitted, received, rejected, or withdrawn. Clearly mark the exhibit number and particular status as indicated by the judge. In some courts, exhibits are marked for identification prior to trial. In other courts, the court recorder is responsible for marking exhibits during the trial. Ordinarily, one of the attorneys states, I would like to have this document or this exhibit marked for identification. How do you make it evidence? I would like to have this document marked for identification. At this point, the operator would note in the log an exhibit was marked for identification. Below is an example. Time 10:03, 293, PX glasses marked. Admitted or received. Okay, just made it evidence. The operator must always note in the log the initial use of any special term or proper name. The operator is responsible for verifying the spelling and the special terms of these special terms and proper names at the time of the proceeding. So they got lots they got to do. Oh, in-chamber proceedings. Mark on the log the counter number and time at which the in-chambers proceedings began and identify the proceeding. Identify all parties and attorney present for the conference at the beginning of the log. Well, apparently, you can have in-chambers proceedings. Maybe you don't need to have it with the judge. You just have it with the judge's recorder. Telephone conversation should be fed into the courtroom or chambers through a speaker box. The microphone should be placed next to the speaker. The log and counter identify phone call between the judge and defense attorney regarding. Okay, so apparently all these things can be done. We're just calling the wrong people to have them done. I think you would call the judge's secretary, and well, they say in the district court that That would be the court recorder appointed by the judge, by the district court judge. Exhibit shall be marked in an exhibit sticker containing the number of the exhibit, the witness's name, date exhibit marked, and reporter's initials. Taken at depositions, which is your affidavit. Administer the oath to the despondent. Excellent. So really, this is what we want them to do. We want them to take our deposition, knowing what the definition of deposition is according to who did I get that from? I got it from Webster. Jeepers, it's gonna be that difficult to remember. Webster said it. Let me get some of these things closed. This one, deposition. The attested written testimony of a witness, an affidavit. That's what we want the recorder to do as the defendant, or if you want to go file a complaint against somebody, right? You want to give your deposition to the judge's recorder as your affidavit of witness. Okay, certified deposition promptly filed with the court in which the action is pending or sent by registered or certified mail to the clerk of the court for filing. Okay. So go to the court where the action is pending, or if it isn't pending yet, then send it to the clerk of that court for filing, I guess, to make it pending. No witness, no exhibits. Administration of oaths. Court reporter are bound to make verbatim record of the proceedings. A judge should not in any way interfere. In addition, a court reporter should not, even on the order of the judge, strike from the record that which is actually took place. Verbatim record. The official record. I don't know what they give us. We go look for a transcript, but we want the official transcript of the record. Of the official record. All court reporters, whether official or these other ones, freelance per diem, must file the format prescribed by the State Court Administrative Office, including the testimony of each witness's name. That's part of the transcript. Title page, name of the court, name of the parties are to be capitalized in their entirety. That's kind of interesting. Okay, well, we're about done with this. I think I just wanted to point out what these things say in them. Use full names of attorneys. This is in the title page. Use full name of attorneys. Spell out street, drive, avenue, cities. Use uppercase and lowercase exactly as shown in examples. When the court is a circuit court, location of the court will always be the name of the court or the name of the county. Okay, then they had that. And then just a few more things down here in these laws. What else does this have to say? Okay, I think we read this, that this was somewhere in that manual. I just want to touch on them just in case. Chief or only judge of the court is charged with overall administrative responsibility for the employees of the court. This responsibility extends to effective management of the court's shorthand reporter or certified electronic recorder. This court should consider adopting written policies covering the following areas. Responsibilities, so forth and so on. The court reporter responsibilities for preparing and furnishing a transcript is set forth in MCR 8. So, of course, taking something else to go read. Exhibits are maintained by Michigan Trial Court Case File Management Standards, Component 20. We're not going to look at that now. It would take too long. The kinds of things I had to put on the paperwork. I want to find where it said they would be the judge. So hang on just a second here. Pause. Okay, this is what I wanted to find. So again, this is for Michigan. And in Michigan, it's the district court where all criminal cases start. And they also do trials for cases that are misdemeanors, right? Less than 1 year. But it's where all criminal cases start. Well, that would mean that's a place you put your complaint in at, is in the district court. And I tried that before by sending them to the judge. I tried sending them to the clerk of the court. None of that worked. But I've never tried to do it to the person called the recorder. So they'll be next. But in the district court then, so this revised Judicature Act 1961, Act 236 of 1961, Chapter 86, recorders and stenographers, there shall be not less than one district court certified recorder or reporter for each judge of the district court who, in addition to acting as official court recorder or reporter, may act as secretary to the district court judge and perform other functions and duties as may be required by rule of the Supreme Court. So it might be good to find all the rules that go with these people, and they're the ones that will have them. But the point is, they're at least the secretary, and they could have other duties. So each judge of the district court shall appoint his or her own recorder or reporter. Well, we just read that. Pursuant to Supreme Court rule, the chief judge or any judge of the district court may appoint additional certified recorders or reporters. Some counties, there's only one district judge. Some, there's many. Each judge appoints their own. The district court chief judge, if there is one, appoints any extras. That's all they're saying. May appoint additional certified recorders or reporters. Appointed additional recorders or reporters shall perform the duties and functions of recorder or reporters when so assigned, and shall perform all functions and duties as may be assigned them by the chief or only judge of the district or the court administrator. So we can get their list of duties from them. Again, that's the Michigan compiled laws for the court where all criminal cases start. And for me, I'm not filing a civil case against somebody to sue them. I want to file a criminal complaint, have the state sue for me, because the attorney general should be my attorney. If somebody's broken the state's law, it's the state's responsibility to have its law enforced and get me a remedy. That's all we're trying to do. Use the system the way it was meant to be. So for Jeff, we'll probably try something with him on this week to put it in to file a complaint into the district court about what's going on. And we'll go from there. Now, just real quick, because there are a couple other things. In here. Here's another one we have going. I mean, this one's already been filed, so for another felony matter, but at the very beginning of a felony matter, not like in Jeff's case where he's going for his trial in a felony matter. Haven't been convicted of a felony before. So I'm sure they had a lot of money into this, and they don't want to let go too easy. So we had to pay them bonds. Well, that was motioned by Dan. Where are you, Dan? Dan. There we go. Okay, so this was Dan's complaint against him. The people of the state of Michigan, had his name in there. Right? No victim or complainant. Somebody using that initial, right, is supposed to be the complaining witness. State of Michigan, County of Montcalm, right? That just established the venue, and hey, it's improper venue. We're not in the county of Montcalm. It doesn't exist. State of Michigan doesn't exist. Well, it may exist, but it's an improper venue. I'm in the state of Michigan, my Macomb County, small c county. Anyways, there was an accident, and unfortunately, a man died in the car accident. But they're saying that the defendant had marijuana in his or her body. Well, you can't have marijuana in your body. There is no such thing as marijuana. Right? It's a commercial term. Why do they call it marijuana? Because you can't charge for hemp, which is the common law name. That's what they made ship sales out of. But on this complaint, so this is what the man's been given, right? There's Dean Allen, prosecuting official. He didn't put no name. There's no complaining witness, whatever. But this is what he's been given. Right? This is the charging instrument against Dan. And so what Dan put in, we did this last week. Right? The state of Michigan, with your information, relator to clerk of courts, Macomb Circuit Court building, to the Macomb Circuit Court, because I believe that's what court he's supposed to be in. But we may go to the district court now based on what just transpired with the recorder and give it to them. I, full legal name, relator for the state of Michigan, victim of deprivation of rights under color of law, codified in positive law as 18 U.S.C. 242, petition this court to discharge this case as the plaintiff's attorney of record is prosecuting this matter in an improper venue, violating my unalienable rights protected by the Constitution of the United States of America. State of Michigan, County of Macomb boundaries are foreign to the state of Michigan, and I am not its resident. It is an improper venue for alleged crimes against the state. Plaintiff, in this case, has no legal standing in the proper venue to prosecute any offense against the laws of the state of Michigan. I ask the court provide me all legal and equitable remedy or relief it deems just in this matter, including the correction of official government records, so these records certify my full legal name as official identification and my domicile in the proper venue of the free and independent state, the state of Michigan. I state your name, relator for the state of Michigan, full legal name of the state of Michigan, have read and certify the foregoing to be true, best of my information, knowledge, and belief, executed June 21st, 2017. So on the day before the verdict was handed down, or not the verdict, but the case was dismissed, Dan put this in to his court by mailing it to this address. Well, now we're going to take this and make a phone call to, as we'll see, the person that a local court recorder, Dan was able to find this online, that Shannon Can, CSR, Shelby Township, Michigan, has been, since 1977 to present, the official court reporter for 41A District Court, which I believe is the district court that this circuit court for Macomb is part of, or under. Right, the district court then is like the court of common pleas, and the circuit court is acting more like the court of chancery. And so we're go to the court of common pleas because that's the court of law to point out that there's been a violation of or deprivation of rights under color of law in violation of 18 U.S.C. 242, and that the court has a duty to prosecute, and they do. We saw that the court recorder is responsible for the laws of the state or of the United States and the state of Michigan. Well, that would be 18 U.S.C. 242. And this is the official court reporter for the court case that Dan is in, where he filed his petition for a motion by mail because of a complaint that doesn't have anybody's damn name on it. And they put him in jail for it. He's already spent a few days in jail. So it'll be an interesting week. That's why I wanted to get this out of the way so I could spend time doing that instead of trying to put it all together in a video. It's a little preliminary, but I believe that is what you say it is. And what I can say is they dismissed a dude's traffic case for no license, no insurance, no plate. Dismissed with prejudice by the state of Michigan. Hoorah. Y'all have a great day. See ya.